Hello and welcome everyone. So today in this video we are going to learn about the fundamental rights of Indian Constitution. So here we are going to deal these fundamental rights in little bit detail, where first I'll be telling you about its introduction and thereafter its feature, and we'll go into the rights in detail, and after that we'll cover up the reads as well as the criticisms and limitations as well. So let us start our today's class. Okay, the fundamental rights are enshrined in part 3 of the Constitution, that is from article 12 to 35. So here you need to remember this one, that it is enshrined, that means it has been included in the part 3, okay, third part of the Constitution of India, that is from article 12 to 35. And that's why this part 3 is of the Constitution is also described as the Magna Carta of India. Okay, this Magna Carta. So what is this Magna Carta? Okay, this Magna Carta is this basically Charter of Rights. Okay, this is the Charter of Rights. The exact meaning is the Charter of Rights, which was been issued by King John of England in 1215. Okay, and this was the first written document which has been related with a written rights. Okay, so that's why fundamental right is also described. Okay, this part 3 is also described as a Magna Carta of India. Okay, and this fundamental rights is been taken, okay, is been taken from Bill of Rights of USA. Okay, Bill of Rights from USA. Bill of Rights USA. All right. So here what you need to remember, that is it is under the part 3 of the Constitution from article 12 to 35, and it has been described as a Magna Carta of India, and this has been taken from Bill of Rights USA. All right. So let us see more about it. So what happened is that during our freedom struggle, our leaders realized that during that movement they realized the importance of rights, because before independence, what happened in India, there was no rights given to the Indian people. Only a few section of people were being given these rights, isn't it? So what happened now, our leaders, they realized this importance, okay, that there should be right, and it should be given to everyone equally without any kind of discrimination. So thinking that these fundamental rights was been included in the Constitution of India by taking into consideration by Bill of Rights, by taking the idea from the Bill of Rights of US. Okay, and these are very important, that the Constitution itself ensures that they are not violated even by the government. These fundamental rights are very much important, okay, very much essential as well for the development and growth of a particular individual, because you will see here how important is fundamental rights, because it is been guaranteed by the Constitution to all the persons without any kind of discrimination. In case if there is any kind of violations of your fundamental rights, now we'll learn about like what are our fundamental rights. Okay, if in case if there is any violations of the fundamental rights, you have the right, okay, you have the right to go to Supreme Court and to appeal it. Okay, so and these are fundamental. Okay, this and why these are fundamental, because they guaranteed and they are being protected by the Constitution. All right. So these fundamental rights are also meant for the promoting of the ideals of political democracy, and also to establish the or to take out, okay, or to present establishment of an authoritarian and despotic rule in the country, and to protect the liberties and freedoms of the people, okay, against the invasion by the state. So in case like people have these rights, in case the people do not have these rights, what will happen? The government will start acting, or the ruling government will start doing whatever they wanted. But here, as the people have rights, not only the government, the other peoples also, that means the powerful will be the mightier, okay, they will be the one who will be ruling, and the weaker section of the people will not have any kind of will not enjoy any kind of rights. So these are important, and as it is been stated in the Constitution of India under part 3, what happened, it has been given to everyone without any kind of discrimination. Okay, and they operates as a limitation on the tyranny, okay, tyranny of executive and arbitrary laws of the legislative. So the fundamental rights acts as a protection. In short, what you need to understand, they acts as a protection for our life. okay, for our development. And this fundamental, why these fundamentals are named as fundamental? See the meaning of fundamental, because they are been guaranteed and protected by the Constitution, okay, and they are essential for all round development, that is material, intellectual, moral, spiritual of the individual. These fundamental rights are essential. If we do not have fundamental rights, then we will not have a freedom to express, will not have the freedom to get an equal opportunity, we will not have a freedom to move and settle any parts of the or any parts of our country, isn't it? Like we'll be limited within only one area, there will be no development. So these are essential for the all round development. So that was a little introduction about these fundamental rights. So before moving into our main fundamental rights, we'll see about what Article 13 says, okay. What are the provisions of, see this under Article 13 you will see provisions of law violating fundamental rights. So it declares that, this does not have, this is law, okay, all laws. It declares that all laws that are inconsistent with or in derogation of any fundamental right shall be void. Means in case if a government introduce any kind of law which is inconsistent and which is going against the fundamental rights of the people, then that will be considered void. Means that law will be considered as void, okay. That means that law will not come into implement, okay, null and void. That means there will be no importance of that law, there will be zero importance of that particular law. That is stated under Article 13, okay. And this also powers, okay, this power has been confirmed, okay, this been confirmed by the Supreme Court under Article 32. Here we will study about this Article 32, where it is about constitutional remedies, okay, right to constitutional remedies, and the High Court under Article 226. And further, this article also declared that constitutional amendments cannot be challenged as it is not a law. If there is any changes in the Constitution, that cannot be challenged, okay, that cannot be challenged as it is not a law. So here there is one example about Keshwanand Bharti case, which is a very famous one, okay, which started around 1973, okay, and it went until 1978, I guess, if I'm not wrong. So here what happens, only in this under this Keshwanand Bharti case, this the Constitution have amended, okay, the Constitution have amended and they have challenged as during that time what happens, one of your rights which has been removed now, okay, which has been removed from the fundamental rights as of now, that is right to property, okay. Right to property was also earlier included under fundamental rights, okay, but included under fundamental right, that was under Article 31, okay. But now what happens after this case, what happened, now this right to property has been deleted from the list of the fundamental rights by 44th Amendment, okay, in the 44th Amendment Act in the year 1978, and now it is made a legal right, okay, under Article 300A in Part 12 of the Constitution. Now it is on the Part 12 of the Constitution. So at present there are only 6 fundamental rights. So let me tell you a little bit about this Keshwanand Bharti case, like what happens and why this right to property. This was not the first time that these fundamental rights, because as this right to property was one of the fundamental rights of the citizen, they started when they feel that their rights is been exploited, they started filing a case, okay, against it on the Supreme Court, because you have the law, isn't it, you have the right under Article 32, under right to constitutional remedies, you have the law and you have permission. If in case any of your fundamental rights has been violated, you have the right to go to the court, okay, and to file a case against it. So what happens under this Keshwanand Bharti case? So Keshwanand, he was a resident of Kerala, okay, and he had a land, okay, which has been given to him by his teacher, and in that land it was a very vast big area, okay. And what happens there, he runs an institution, okay, he runs a school where thousands of students were studying. So what happens when government introduce any of his development provision in that very area, so the government asked his land, okay, which was in which he was running his institute, okay. So here Keshwanand he have not agreed to it. The government was asking the land and the government was ready to pay the compensation, and the government used to pay the double the value of that land, okay, whenever they used to pay compensation. See, like example here, in present day also you might have seen that when government had any project of expanding our highways, especially in highways, and the homes which are near their houses which are near the highways, okay, if any person have their lanes near the highways, because in order to expand the land, the government needed that land, isn't it? And the government used to ask the people to give their land, and they will be giving compensation. And this is happening, isn't it? In every sector this is happening, especially in Delhi, NCR, Gurgaon, you can see, isn't it? And they are getting 3 times more than the value of the land. So in that but here what yes, they are getting 3 times more, so they have these rights, okay. But this happens only after this Keshwanan Bharti case, and when this right to property was removed from the fundamental right. So here, as Keshwananda did not agree to it, he was not willing to give his land, okay, he was not willing to give up his land, as he was running an institution and he was thinking for those thousands of students, all right. So he filed a case in the High Court first, so telling that he is not he's not agreeing with the government. He don't want to give up his land, as the right to property was a fundamental rights, isn't it? So there he was not there. The High Court has given the decisions against Keshwanan Bharti case. So again he went to Supreme Court, because he has the right to go to appeal to the Supreme Court. And what happens when he went to Supreme Court? Again, there at that time there was a jury system, okay, and in that jury system, what happens, those at last the jury members have to tell their decisions. So there also 6 of the jury member were given decision in favor of Keshwanan Bharti case, and 7 of the other jury member, they have given against it. So there also he was not the case was not the case was not on his behalf, okay. Again, the case was in favor of the government, in favor of the state government, we can say the Kerala state government. So what happens after that, the government realized that we should remove this right to property from the fundamental list. Why? Because when Keshwanand has registered the case on the Supreme Court, he have also registered that his fundamental rights are violated, okay. And when he registered in that way, this spreaded, okay, this news spreaded in whole of the country. And like now all the people were listening to it, okay, were listening to it. In today's language, if you can see, his case went viral, okay, it went viral, and like now everyone were listening and was seeing whether the Keshwanan Bharti case will get justice or not, as it is a fundamental right which has been enshrined in our Indian Constitution. So that makes this case very famous, okay. And after that, government realized, and in the year 1978, this right to property was completely deleted, okay, from the list of the fundamental rights under 44 Amendment Act. So this was about Article 13. I hope you have understood, okay. And okay, now next, so now before starting the 6 fundamental rights, let us see some of the features of these fundamental rights, okay, so that you will get a greater idea about these fundamental rights. These fundamental rights, unlike ordinary legal rights, are protected and guaranteed by the Constitution. These are not an ordinary or legal rights, okay, these are fundamental in nature. That is why it has been protected and guaranteed by the Constitution of the country. And these rights are available to the citizens of India. All of the rights are available, okay, while others are available to the persons. Some rights are not available to the person in case if they are foreigners, okay, or legal persons or corporations or companies. See, these rights, in case if they are citizens of India, all of these rights are available, and in case if they are foreigners, there are some rights which are not available to their foreigners, okay. So let us see the next feature, that is fundamental rights are not absolute, okay. These are not absolute but qualified. Why not absolute? Because there are certain restrictions here, okay, imposed by the state. There are certain reasonable restrictions, because see, in case of right to freedom, you have right to express, right to do, right to live, or right to whatever you wanted to do, isn't it? But that doesn't mean that you will hamper others' fundamental rights. Okay, you have the right, your rights are fundamental as long as you doesn't hampers others' fundamental right. Like you have your rights, the other person will also have the right, isn't it? For example, here let us say, like you cannot go into the hospital and start playing a loud music, isn't it? And also at your homes also you cannot play very loud music and you are disturbing your neighbors. That means you are exploiting their fundamental rights. You have the right to hear a song or anything you wanted to do, dance or anything, but you should do that things in limitation. That is why they are not like absolute. Okay, that's why there are some reasonable restrictions over them. Okay, for example, during emergencies, in case an emergency is declared, okay, not internal emergency, external emergency. In case of external emergency, then what happens? Your rights, your fundamental rights will be suspended. About that we'll see again in our next feature. Okay, here what you need to understand, these rights are not absolute but qualified. Why? Because there are certain reasonable restrictions on them, and I hope you have it is cleared by that example. Whatever you are doing, it should not hamper the others' fundamental right. You should take care of that as well. Okay, only then there will be a balance between the rights of the individual and those of the society as a whole. Okay, between individual liberty and social control. Next, fundamental rights are justiciable. See, this is the biggest advantage of fundamental rights. Means this, in case any case of your rights are being violated, you have the right to go to the court. You have the right to move to the court for enforcement whenever they are being violated. Okay, it allows a person to move to the court, and the aggrieved person can also go directly to the Supreme Court in case of the violation of any of their fundamental rights. You can go to the Supreme Court also. For example, here if we talk about directive principle, which is in the part 4 of the Constitution, okay, that are not done. Those are directive principles are non-justiciable. Means in any case, so in any rights mentioned under a directive principle are violated, you don't have the right to go to the court and file a case against it. But here, in case any of your fundamental rights are violated, then you have the right to go to the, you have the right to move to the court for, and you have the right to appeal a case against it. Like you will be asking justice. Okay, like my fundamental rights has been exploited, I want justice. That is why it is justiciable. Okay, now let us move to our fourth feature. Fundamental rights are not sacrosanct or permanent. Okay, why these are not permanent? Because whenever any changes Constitution want to bring, they can bring, but there is one the condition here, without affecting the basic structure of the Constitution. This is very important. Okay, if they want to curtail or repeal or or makes any amendment, but not by an ordinary act. Okay, it should be a special act, and that should be done without affecting the basic structure of the Constitution. Okay, the basic structure of the Constitution should not be curtailed. All right. Next, suspensions of rights. See, this was I was talking about. Okay, they can be suspended during the operation of national emergency. Okay, except under this also, except their rights which has been guaranteed under Article 20 and 21, and especially under 21. Okay, the right to life is there. Okay, right to life is here. Right to life, it is under Article 21. So no one can take your right to life, isn't it? You have the right to live, isn't it? Right to live your life. So all the other rights will be suspended except right to life. Okay, and right to live. So here, during that is also only during national emergency. Okay, national emergency, which will be from external force. Okay, which will be from external force, not internal one. All right. And under this, the 6 rights guaranteed under Article 19 can be suspended only when emergency is declared on the ground of war or external aggression, that is external emergency, and not on the ground of armed rebellions or internal emergency. So this is what I was telling you about, that only when there is an external emergency or external war, okay, declared in your country, then all your rights, this Constitution have rights to suspend all the rights, okay, all the fundamental rights that you are having. Okay, Okay, so restrictions of law. See, there will be certain restrictions on the fundamental rights. There are limitations. Okay, you have been given fundamental rights, but there are some limitations as well. Okay, the application to the members of armed force, paramilitary force, police force, intelligence agencies, analogous service can be restricted or abrogated by the Parliament under Article 33. Okay, because there are certain see, these military, paramilitary force, they have a different rules and regulations, isn't it? So in that case there are some restrictions. Okay, there are some restrictions here. So their application can be restricted while martial law is in force in any area. Okay, in case if there is any martial law in any area, then martial law means military rule. Okay, in case if there is any military rule imposed under some abnormal circumstances, then these rights will be suspended. Your rights will be suspended and there will be restrictions of rights. Okay, so in this case it is different from national emergency. So those were some of the feature, okay, highlights you can say of fundamental rights. So now let us come to these our main 6 fundamental rights. And before that, as I have told you that right to property was also under a list of fundamental rights. Before we had 7 fundamental rights, now we have only 6. Why? Because right to property, which was under Article 1, is been deleted, okay, from this fundamental under 44th Amendment Act 1978 after that Keshwanand Bharti case. Okay, and now it is a legal right under Article 300A and it is included in Part 12 of the Constitution. So now at present there are only 6 fundamental rights. Okay, so let us see that 6 fundamental rights and we will be dealing it in detail as well. Okay, the first is right to equality, which is from Article 14 to 18. Okay, right to equality comes under Article 14 to 18. Second, we have right to freedom, that comes under Article 13 to 20, Article 19 to 22. And third, we have right against exploitation, that comes under Article 23 to 14. So we will be dealing all these things in detail. So here I am just mentioning these rights, okay, and under which article they are. Okay, so next we have rights to, this should be here. Okay, next we have right to freedom of religion. Okay, right to freedom of religion and cultural and educational rights, that is from Article 29 to 30. And last we have this constitutional remedies. See, this constitutional remedies should be here in this place. Okay, there has been mistake here. So right to constitutional remedies, which is in Article 32, and this is very important. Okay, because and this is also called the soul. Okay, soul of fundamental rights. You can say soul of fundamental rights. All right. And why it is called the soul of fundamental rights? Because it is under these constitutional remedies only. Okay, you have the right, in case in any of your fundamental rights are violated, you have the right to go to the court and appeal a case against it. Okay, and ask for justice. So these are the 6 fundamental rights. Hope you will remember. Here what's important, you should know the articles here. Okay, like for example, right to equality comes under Article 14 to 18. So now we are going to discuss in detail what comes under 14, 15, 16, okay, till Article 32 we are going to discuss. And about Article 31 we are not going to discuss because it was a right to property and it has been already deleted from the Constitution. All right. So now let us start our 6 fundamental rights. First, we have right to equality, that comes under Article 14 to 18, isn't it? So here it means, from the name itself, what we can guess means equality, means everyone is equal. Okay, everyone is equal and there should be no discrimination. Okay, there should be no discrimination or any kind of practice, okay, which will be considered as like which will hampers the person. Okay, here this means this ensures the state shall not deny to any person equality before the law or equal protection of the law within the territory of India. Means the state shall not deny, okay, to any person equality before the law or equal protection, means everyone will be equal in the eye of law within the territory of India. and it prohibits arbitrary discrimination by the state and guarantees equal treatment under similar circumstances. So this was under Article 14. Everyone is equal. Simply you can understand like that, everyone is equal without any discrimination. So what comes under Article 15 now? This prohibits discrimination. So see here in Article 14, everyone is equal. You understand like that, everyone is equal. Okay, everyone is equal. And Article again 15 provides that prohibits discrimination on the grounds of religion, race, caste, sex or place of birth. Means you should not be discriminated. In case if anyone is found to be discriminating you, like he or she is the so-called upper caste people, and he's been practicing some kind of discrimination with you, or regarding your religion, race means the color of your skin, isn't it, like black or white, because everyone is equal. Now you cannot say that black people should not get the rights and only white people will be getting the rights. Such discriminations is prohibited completely, and it is a crime. Okay, it is a crime according to the Constitution of India, and in anyone is found practicing it, he or she will be put behind bars. Okay, so there will be no discrimination regarding religion. Okay, regarding race, like religion, we have so many religion: Hindu, Muslim, Sikh, Jain, isn't it, Christian. And caste, whether you are from upper caste, higher caste, it doesn't matter, everyone is equal. Sex means here gender. Okay, whether like especially the women are been have faced lots of exploitations, and the rights were also not given to them initially. Education's rights was also not given to them, but now what happens after the independence of India, now women also have the rights and equal opportunity to do whatever they wanted to do. And place of birth, for example, if you are born in a mainland, is let's say Delhi, then you cannot discriminate a person who is coming from the northeastern part. Okay, northeastern part or from the south. Everyone is equal and everyone is Indian as much as you are. Okay, you should remember that. And it also, yes, so Article 15 means there should be no discrimination in case of religion, race, caste, sex or place of birth. It ensures that no citizen shall be subjected to any disability, liability or restrictions. Okay, so that was Article 15. I hope you understood. Next we have equality of opportunity in public employment. This is important. Okay, this come under Article 16, means equality of opportunity. Provision guarantees equality of opportunity in matters of public employment or appointment. Means you are equal opportunity will be given. Suppose there are some vacancies created in a government job, then everyone will be given equal opportunity to write the exam. Everyone will be invited if they have cleared the exam. Okay, there will be no discrimination like you have come from the lower class, so you will not be able to give the exam. Such discrimination is strictly prohibited. Everyone is equal, everyone has equal opportunity, men, women, everyone. Okay, so this also prohibits in case of religion, race and caste, gender, place of birth or residence. Everyone is equal of opportunity would be given to you. That is under Article 16. Okay, next Article 17, let us see what does Article 17 say. And Article 17 is very important as well. It states the abolition of untouchability. See, in India there was a casteism, isn't it? Caste system was being practiced in India for a very prolonged period of time. That is why there are reservation included. Because due to caste system, what happened, the lower caste people has been deteriorated, isn't it? They were not given any chance of development. They remain underdeveloped because you cannot change a profession according to it. If you are born poor, you'll be dying poor according to casteism. So in order to make them uplift, in order to bring upliftment and in order to bring development for that lower caste people, first especially we can say Dalit people, isn't it? Dalit people or the Dalit people, now there are some provisions provided to them. Okay, special provisions, for example like reservation and all. So it is all because of the practice of untouchability. And now in case what happens, if you find anyone practicing untouchability, that is considered as a crime now. Okay, he or she will be punished and can be put even behind bars. So this provision abolishes untouchability. So Article 17 abolishes untouchability. Okay, it recognizes untouchability as a social evil. Okay, and it ensure its eradication completely. Okay, and because of this untouchability there was a discrimination, isn't it? Discrimination was there. So this should be completely eradicated. So this, it has been completely eradicated already, okay, there it has been abolished now. So let us see our next article, that is article 18. Okay, so under article 18 what is there, let us see. This provisions prohibits the states from conferring titles. Okay, see, conferring titles. Now you cannot add any kind of title before you until and unless it is a military title or academic titles. Okay, that means like you cannot add Nawab or Sheikh or something like that before your name, because earlier India was been your country which has been ruled by kings. So like that time Maharaja, these, that, isn't it? They used to have titles, but here now you cannot have any kind of title. You cannot treat yourself as a special person, because everyone is equal before the eye of law. Now here their exception is that the military titles will be there. Okay, like for example captain, major, isn't it, general, lieutenant general, such titles are been you can use such a title because it is under military. And academic distinctions, for example, you can add, if you have done engineering you can add engineer, or if you have done PhD you can add doctor, isn't it? If you are doctorate you can add doctor before your name. Only such titles are allowed, others titles are not allowed, which in case which in case will be touches or it sees the discrimination. Okay, if it makes certain kind of discrimination, then such titles are not allowed. All right, so that was under article 18. So this was all about right to equality. We have discussed each and every article, that was from article 14 to 18. I hope you have understood. In case if there is any doubts or anything, you can ask, you can comment down. Okay, you can ask in the comment section. I'll try to resolve your question. So with this, let us move to our next right, that is right to freedom. Okay, our second right, that is right to freedom. So here it is under article 19 to article 22. All right, so here it guarantees individuals liberties and freedom. All right, so here under article 19, okay, only under article 19 itself there are six rights given, six rights or freedom given to the individual. Let us see all of those in detail. Okay, so it is from article 19 to 22. So first let us see on article 19. Okay, freedom of speech and expression, this is under 19(1)(a). Okay, freedom of speech and expression. Now you are free. Okay, you are free to of speech and expression in case if you are not happy with any decisions of the government taken, okay, on the about the recent law or anything, then you have the right to criticize them. You have the right to express your freedom. You have the right to express your thought. So that comes under article 19(1)(a). Okay, it gives freedom to express their views, opinions, beliefs, convictions, okay, through speech, writing, printing, or any other mode. And some regional restrictions can also be imposed by the state. Okay, for like for example, freedom of speech and expression doesn't mean that you are going to defame any particular person or defame any particular institute or governmental organization. You cannot do that. Okay, you cannot do that. You have a freedom to practice it. You have freedom of speech and expression, but within limit. You will be doing it within limit without defaming the other person. All right, so that comes under article 19(1)(b). So 19(1)(a). Now is under 19(b). Let us see what is it. Freedom to assemble. Okay, freedom of assembly or forming union or anything that is peacefully without using arms. Okay, citizens have the right to assemble peacefully, and this includes like right to hold public meetings, demonstrations, processions, like you are taking right to strike, rally, dharna, whatever you are doing, you have that right, isn't it? So that all comes under article 19(b). Okay, now article 19(c), what it is? Freedom of association. Okay, individuals have the right to form association and unions or cooperative societies, enabling them to cooperatively pursue common interest or goal. In goals. So here what happens? Individuals have the right to form association, union, Cooperative, for example, see, association means we have different association for different profession. For example, the working class have a association, working association, isn't it? The labor group have labor association. The doctor will having their association. The nurse will be having their association. Teachers association, business class group associations. Like that, you have the right to form such associations and unions. Okay, so that you will be able to run your common interest collectively. So, but while forming such associations, there are again certain restrictions as well, okay, imposed in the interest of public order and morality of the sovereignty and integrity of India. So, you will, before forming any association, you should be looking into that you are not hampering the interest of public order or the sovereignty and integrity of India. Means you are not going to do any such works under that associations which is going to defame your country's sovereignty or integrity. All right. So, that was under Article 19C. Now, let us see 19D. Okay, every citizen has the right to move freely throughout the territory of India. Here means freedom of movement. You have freedom of movement under Article 19D. Means you have the right to move, and you have the right to move in any parts of your country, and you have the right to settle over there also. Okay, you have that right. If you want to settle in Delhi, you can settle in Delhi. If you want to settle in Mumbai, you can settle in Mumbai. If you want to settle in Manipur, you can settle in Manipur. If you want to settle in Kerala, you can settle in Kerala. No one will say that, no one will be telling you that, okay, you are not the residents of this area, you are not allowed to settle here. If you have bought that property, if you have bought that land, then you have the freedom to settle over there. Okay, that means you have a right of freedom of movement. All right, and here the restriction is that you should not you should not hamper the interest of the general public and protection of the interest of any scheduled tribe. Okay, you have right to movement, but you should be careful here. Okay, like you are not imposing or you are not defunctioning any of their rights. So, freedom of residence. Here, citizens have the freedom to reside and settle in any. Okay, there is a mistake here. Here, there is a freedom of movement. Okay, and about settlement, it is under Article E only. Okay, under 19E. So, there was a mistake here. So, here you have freedom of movement, means anywhere you can go and you can see, isn't it? Like whenever in vacations also you used to go in different states and you used to stay and enjoy there. So, you have a freedom of movement in any part of your country. Okay, but there are certain restrictions, like you cannot say that I want to go and see inside. If you are not a military person, you cannot go into a military area, isn't it? Or certain areas, certain restricted areas are there, or certain jails are there. You cannot say that, okay, I want to go and I want to see that particular criminal over there. Such restrictions are there. You should be moving in your limitations. Okay, so that was about freedom of movement. Before I have made a mistake over here. And now next is freedom of residence. So, here you have the right to settle. Okay, citizens have a right to settle in any parts of India. Allowing means anywhere, wherever you wanted, as I have explained earlier, anywhere, wherever you wanted to settle, you can settle over there. Okay, so that comes under Article 19E. And CF under next will be dealing G, and why F has been deleted, well, I'll be telling you again, because it is related with right to property here. Okay, so under Article 19G, individual have the right to practice any profession. Okay, any occupation you want. Okay, or to carry any occupation, trade or business of their choice, subject to certain restriction imposed in interest of general public. See these restrictions will be everywhere. Okay, in every rights there you will find restrictions. Why? Because you have to practice your fundamental rights, or you will be doing practice your fundamental rights or using your rights, as long as you are not hampering others' fundamental rights. You should be taking care of that always. That should be in your mind. Okay, like the example which I have given just before, you cannot play loud music in such hospitals or such a place, isn't it, where you cannot do that. Is your limitation. isn't it? For example, under noise pollution also, noise pollution is also included under your Article 21, because in your home also you cannot play a very loud music if you are disturbing your neighbors. You should also think about them. You can play music, but as long as the sound is not going outside and the sound is not disturbing others. Okay, so here, okay, let us come back to this 19G. Okay, so here what happens, individual have the right to practice any professions. For example, no one can force you, like your parents are teacher, you will be becoming teacher, because in case of caste system, what happened, if your parents are cobbler, you will be cobbler. If your parents is a high caste Brahmin, you will also be a Brahmin here. But not in case of now independent India. Now whatever occupation you wanted to pursue, you can pursue it without any kind of discrimination. If you wanted to go into trade or businessman, you can be that's your choice only. Okay, whatever you want to become, if you want to become teacher, you can become teacher. If you want to become doctor, you can become doctor. And now there are so many jobs open up to under IT sector, so whatever job you wanted to do, you can do it freely, isn't it? Okay, so here about F, let us see. The right to acquire, hold and dispose of property was one of the fundamental rights and enshrined in Article 19(1)(f). Okay, so it is under Article 31. So here that right to hold and dispose of property was given there. Okay, under Indian Constitution 1. So it was under Article 19(f). So it has been deleted. So now we are not going to talk about it. Okay. Next, let us see Article 20. Okay, under right to freedom. So we have already discussed Article 19. Alright, now we will be discussing Article 20. So here under Article 20, what does it gives? It gives protection in respect of conviction of for offences. That means you will be not in case if you have been punished, or in case if any accused person is been punished, okay, then there will be protections for him also. Okay, because there should be no excessive punishment. For example, if he is been imprisoned for 1 year, then after 1 year he should be coming out, and whether during his tenure inside the jail, let us say, then no one, he should not be harmed, or he should not be beat up, or any such exploitation should not be done. Okay, so this comes under Article 20, means excess punishment should not be given. Okay, excessive punishment should not be given to a accused person, whether a citizen, foreigner or a legal person. All right, whatever the court have decided, that particular punishment should be given, not exceeding that level of punishment. And one more important thing here, you have to see, a person cannot be tried and punished again for an offense for which they have already been either executed or convicted. Means if a person have committed any crime and he have went to jail for that very crime for 2 years, then that person will not be again put up to or sent to jail again for similar crime. Okay, for that particular crime, that such protection it is here. Okay, protections against self incrimination, which is under Article 23, and this is under Article 22. So that was about Article 20. Now let us see Article 21. So Article 21 is it's important also. Okay, because here you have the right to live. Okay, right to health, like you have right to privacy, all comes under Article 21. So this provision guarantees that no person shall be deprived of their life or personal liberties. See, under personal liberties, what will come? There will be right to privacy. Okay, right to privacy, right to live, right to health. All right, such rights all comes under Article 21. So here they should not be deprived. Okay, and like you also have right to sleep also. Okay, but that doesn't mean that you will be sleeping the whole day, or will be sleeping when you are going in your job, because when you are doing job in a certain institution, they have been given payment due, so that will be your limitation there. Okay, like you cannot sleep over there because they have been you are being paid for that particular job, and you will be doing work for them. Okay, and you have right to privacy. Okay, so all this come under Article 21, and the most important here is the right to live, because this during emergency also, during national emergency also, no one can take your right to live from you, and that comes under Article 21. Okay, and one more important article is there, important provision is there under Article 21A. All right. So this guarantees right to free and compulsory education for children aged 6 to 14 years. Okay. See, you have seen government institutes are there in every district. 2 to 3 government institute will be there, isn't it? Government schools, sorry, not institute, I can say school, primary schools are there. Why? Because the government want to ensure that each and every one, because the poor people, they cannot send their children to school. So the government has made free and compulsory education from children 6 to 14. At least they will be getting their basic education and they will be learning how to read and write, so that no one will remain uneducated. So this is the provision of government which is under Article 21A. All right. And it also mandates the state to provide access to quality education, okay, ensuring that every child has the proper opportunity to receive educations without any kind of discrimination. Means there should be no discrimination, and this was been added under 86th Constitutional Amendment Act 2002. So this has been added very recently, only 22 years before. Okay, so now everyone have see, this is especially helpful for those poor people, okay, because they are not able to send their children to school. And here one more thing has been introduced here, midday meal, isn't it? Midday meal has been introduced. Why? Because government have felt that there has been decrease in the attendance of such children, and when surveyed, what they found, because the parents, as they are poor, they thought that the children, if they also went with them, then they will earn little money and they'll be eat something. So what happens is, saying that into respect, government introduced midday meal scheme also, isn't it? And now the child, if they are coming to school, they will get meal, full meal, okay, full stomach meal. That means bhar pet khana, isn't it? Because it's very difficult for them to get even a one-time meal. So such initiatives are being taken up by government for the betterment of the people and for the development of such children, okay, so that they should not be betrayed from right to health. See, because right to health is also there under Article 21A, isn't it? Okay, so that was about Article 21. Next, let us see about Article 22, that is protection against arrest and detention. So here what comes? It comes protections against arrest and detention. This provision ensures certain protections to person who are arrested or detained, okay, including right to be informed. Suppose you cannot arrest any person directly by going their home, okay, or going into their house. You should inform that person particularly, like why he or she has been arrested, and that person should have a right to consult and defended by a legal petitioner, means they have a right to consult a lawyer, okay, and they are also have right to produce before the magistrate within 24 hours of arrest. That means if you have arrested a person, it doesn't mean that you are going to keep that person behind bars 2 to 3 days without any prosecutions or anything, okay. So it prevents arbitrary detention and ensures fair treatment of individual in custody. So here the accused person, you can say, okay, the one they have arrested, they have the right to be informed why they are being arrested, okay, why they are being arrested, and he or she have a right to hire any legal practitioner, okay, and he or she should be produced before the magistrate within 24 hours of arrest. So this comes under Article 22. So that was all about right to freedom. So we have completed right to equality and right to freedom. Hope it is clear with everyone. In case if there is any query, you can ask in the comment section, okay. So next, let us see rights against exploitations, okay. Next right, that is the third right we are dealing with now, okay. Right against exploitation, that is from Article 23 and 24. It is in Article 23 and 24. So this provision of Indian Constitution provides safeguards to protect especially people, vulnerable section from exploitation, okay. So here let us see which rights are included. So under Article 23, prohibitions of traffic in human beings and forced labor. See, slavery, okay, this is the slavery, isn't it? Now you cannot keep any slave if they are not willingly staying with you, isn't it? Like in earlier days in ancient Indias, there used to be slaves, isn't it, bonded laborers and forced labor. In case if a pigeon is not pigeons is not able to return money of that jamindars or money lenders, what happens? The jamindars will be taking away your son, isn't it? Like be saying that, okay, I'll keep him as long as you are not paying my debts. So that was a bonded laborers, isn't it, forced labor. So now such prohibition is there. And trafficking of human beings, now you cannot sell, isn't it? No, you cannot buy or sell any human beings. Say such cases are very much going on, but this has been prohibited according to Indian Constitution, and it is one of your fundamental rights. Okay, like no one has the right to sell you or buy you. All right, so this prohibits human trafficking and forced labor, and if you are found doing it, you will be found guilty and you will be punished for such offense. And under Article 24, prohibitions of employment of children in factories. Okay, you cannot employ any children the age of 14, okay, under the age of 14 in any factory or mine or in any hazardous activities. Okay, and it will be a crime if you have employed any children who is under the age of 14 into a hazardous factories or anything, because it will affect their health, isn't it, affect their health. And until the age of 14, government have given right to be educated, isn't it, compulsory and free education. So you cannot employ any children under the age of under the age of 14. Okay, that is given under Article 24. So that was about rights against exploitation. Next, the fourth right we are going to study here is right to freedom of religion. Okay, so here this right to freedom of religion, it is from Article 25 to 28. Okay, so what happens here? So it guarantees individual the right to like freedom to profess, practice and propagate the religions of their choice. Means whatever religion you wanted to opt for. If you want to opt Hinduism, if you want to become Hinduism, a Hindu, you can become Hindu. If you want to become Muslim, you can become Muslim. If you want to become Christian, you can become Christian. No one will be telling you, or no one will be punishing you for adopting any religion of your choice. Okay, you have right, you have freedom to profess, practice and propagate religion of your choice. Okay, it is because India is a secular country, isn't it? It is a secular country, and in order to maintain neutrality, it treats all religion as equally, as no religion will be treated very like specially. Every religion is same as per the constitution. As why? Because India is declared as a secular country, isn't it? So you have freedom to profess any choice religions of your choice. So here Article 25, let us study in little bit detail about Article 25. So what does Article 25 say? Article 25 says freedom of conscience. Okay, freedom of conscience and free professions, practice and propagations of religion. Means you can practice, okay, you can practice or you can propagate any religion of your choice. Freedom of conscience, freedom to right to profess, right to practice and right to propagate any religions of your choice. Under Article 26, freedom to manage religious affairs. You are free to manage religious affairs. Okay, so means you have right to establish and maintain institution for religious and charitable purpose. Okay, and you have right to manage its affair in matter of religion. You have right to own and acquire movable and immovable property in case of religion. Okay, and right to administer such property as per law. Means you have freedom to manage religious affairs of your own, but with limitations. Okay, but with limitation. You should not forget there are always limitations. Next, you have under Article 27, that is under right to freedom of religion only. Freedom from taxation for promotion of a religion. Means if you are donating any amount in the name of religion, there will be no tax levied by the state. Okay, that the state is not entitled to take any taxes to a religious funds. All right, so that is under Article 27. So it is given here, prohibits states from levying tax for promoting or maintaining any particular religion or religious denominations. All right. Next we have Article 28. So next we have freedom from attending religious instruction, that is under Article 28. Okay, so what does it mean? It means that institutions, see there are some clause here. Okay, it makes provisions for religious instruction in different categories of educational institutions. Okay, so this is regarding the religious instruction carried out to be in an educational institutions. For example, what does the first clause say? It says that in case if the institution is wholly maintained by the state, okay, religious instruction is completely prohibited. For example, government government schools, okay, in government schools, for example, institutions, under institutions came the army institutions, okay, in Indian Navy institutions, Indian Air Force institutions, and like Kendriya Vidyalaya, Navodaya Vidyalaya. So under such institutions which comes totally under government, okay, under government, then what happens? There you cannot impart any kind of religious instruction. That means like there you will not be allowed to propagate your religion or anything, okay, anything which is in connection with religions, they should not be celebrated. For example, in a government school you will not find anyone celebrating any religious ceremonies over there. For example, Saraswati Vandana or anything, Saraswati Puja, anything, you should not be conducted, okay, it should not be conducted because it is given here under Article 28. And in case institution administered by state but established under any endowment or trust, religious instruction is permitted. So in which religious instruction is permitted? In case institute is administered by the state but it has been established under certain trust or endowment, okay. And next, institution recognized by the state and on a voluntary basis, okay, but with the consent of the person, means it is not run by the state, it has been recognized by the state. And institution receiving aids from the state, religious instruction is permitted on a voluntary basis with the consent of the person. Means here what you should know, an institution which is wholly maintained by the state, religious instruction is prohibited. In other cases, religious instruction is permitted. All right. So that was under Article 28. So we have completed about right to freedom of religion as well. I hope you have understood. Next, let us come into cultural and educational rights. Okay, cultural and educational rights, which comes under Article 29 and 30. So this provision of the Indian Constitution safeguards the rights of especially the minorities to conserve their culture, language and script. Okay, here the name itself, it suggests cultural and educational rights, especially of the minorities. Means if certain the minority groups, they have the right to maintain their culture, their language, their script, okay, it is their fundamental rights. So here let us say under Article 29, what does it says? It provides any section of citizens having distinct language or means different language, okay, which has not been commonly spoke, script or culture of its own, shall have the rights to conserve the same. They have the right to conserve their language, script, culture, okay. And no citizen would be denied admission into any educational institution maintained by state or receiving aid out of state funds on grounds of religious, race, caste or language. There should be no discrimination, okay, in any educational institution run by the state or run by the aid of the state. Everyone, every minority group, especially the persons from individuals from the minorities, they will get equally admitted as others, okay. No, they will not be treated differently. So that is under Article 29, okay. That means what you have to remember here, you have the right to conserve your language, script or culture, okay. And you are not denied of admission into any educational institution because of your caste, race or languages. All right, that is under Article 29. So under Article 30, rights of minorities to establish and administer educational institute. So rights of minorities to establish and administer educational institutions. So here it provides, okay, this provision grants minorities both religious as well as linguistic, okay, the right to establish and administer the educational institute of their choice. If they wanted to establish any institution, educational institution, then they have the right to establish, and they also have the right to give the education, they impart education on their to their children in their own language also. If they wanted to make the children learn their, or make the children to learn in their own language, then they have their rights as well. Okay, and here it is for all section of the people. Okay, it is noted that protection under this provision is confined only to minorities, religious or linguistic, and does not extend to any sections of people as under Article 29. So here you have right of minority specially to establish and administer educational institute of your choice and to impart education to their children in their own language. So that is under Article 30. So with this we have completed cultural and educational right as well. Okay, next we have constitutional remedies. Okay, here there is a mistake. Okay, these rights of minorities should not come over here. Okay, there is a printing mistake over here in my slide. All right. Okay, so right to constitutional remedies. See, as I have told you before, this is the soul, okay, soul of fundamental rights. All right, because under this constitutional remedies only you have the right to go to the court and enforce anything, okay, or file any case in case if your fundamental rights is violated. Okay, it confers the right to remedies for enforcement in the fundamental rights in case of violation of the same. And here you have the right to move to Supreme Court. Okay, and it will be guaranteed that justice will be provided to you, and the Supreme Court has the power to issue directives or orders of writs for the enforcement of fundamental rights. See, we are going to learn about these writs also in detail. Okay, so here Parliament can also empower any court to issue directions, order, writs. Same case here, Supreme Court, Parliament, any other courts can have the power to issue or directions or orders or writs for the enforcement of the fundamental rights. If your fundamental rights are violated, then you can go to the court and you can file a case against it. That is why fundamental rights are justiciable, isn't it, as we have learned this in the features of fundamental rights. Okay, here again there is a mistake over here. Okay, the rights to move to the Supreme Court shall not be suspended except as otherwise provided by the Constitution. See, you cannot suspend the right to move to the Supreme Court. It is given under Article 32. Okay, and these provisions give the right to get the fundamental rights protected. So this is the most important fundamental rights. See, we have fundamental rights of right to equality, right to freedom, cultural and educational rights, rights and against exploitations, but which is the right that protects all of our fundamental rights? That comes under right to constitutional remedies. Okay, so these were the 6 fundamental rights and we have learned it in detail already. I hope you have understood. You can comment down, and yes, don't forget to subscribe my channel to support me. Okay, and click the bell icon as well to reach the notification in time and you don't miss any updates from my sites. I hope you are liking this session of fundamental rights. Okay, I'll bring such a more session about directive principles, dealing with the Indian constitutions. Okay, everything I'll bring it, more videos. So I have started this with these fundamental rights. I hope you will support me in this journey. So we have completed all the 6 rights. Okay, now let us see the 5 writs which is under this constitutional remedy. Like here, as there was a provision, isn't it, the Supreme Court or the Parliament can empower any court to issue order or writs. So about this writs, okay, this writs is under constitutional remedy. So let us see about those writs. Okay, so the 5 writs we have under our constitution is, first is Habeas Corpus, Mandamus, Quo Warranto, Certiorari and Prohibition. So here we are going to study about these Habeas Corpus, Mandamus, Quo Warranto, Certiorari and Prohibitions a little bit. Okay, little bit in detail. So I hope all of you are ready. So now let us start with the writs. Okay, writs under constitutional remedy, that is under Article 32. All right. So first, habeas corpus. Okay, what does this habeas corpus means? Habeas corpus literally means to have a body of, in case if a person is accused or is been arrested. Okay, under this writ, what they will order, what the Supreme Court, especially the Supreme Court, here they will order that a person has to be informed, like we have done under right against exploitation, that whenever you are arresting any person, he or she should be informed here, isn't it? So in case any person is been unlawfully detained or imprisoned, okay, this writs is used to release such a person who is been unlawfully detained or imprisoned. And by the virtue of these courts, what happens? The courts direct the person to so detained to be brought before it to examine the legality of his detention, means brought before. That is why there's this term to have the body, it is related over here, okay, means the court will direct the person to bring the body, okay, to bring the person, to bring the person before the court and examine whether this person is been detained lawfully or unlawfully, okay. And if the courts concludes that the detention was unlawful, then the person would be released immediately. Suppose it happens, isn't it, peoples are being arrested without prior informations, and suddenly they are being arrested in such cases, and in case if they are not found guilty, then they have the rights. In case if they are not guilty, they know that they are not wrong, then they have this right to use this writ, which is habeas corpus, all right. And there are certain circumstances, okay, of unlawful detention. Let us see. If in case if the detention was not done in accordance with the procedure laid down, for example, say if a person was not produced before a magistrate within 24 hours of his arrest. I hope you remember on right against exploitation, we have seen that a person, he should be informed and he should be produced before the magistrate within 24 hours, isn't it, of his arrest. In case if this is not done, then these writs will be produced, okay. And the person was arrested when he did not violate any law, okay, without violating any law, in case if that person is arrested, and this arrest was made under a law that is unconstitutional, okay, without any arrest warrant or anything, we have simply caught the person and you have brought the person over in the you have put the person over bars, okay, behind the bars. So in certain case, this habeas corpus would be released, okay, this writs will be released. So that was about habeas corpus. I hope you have understood. Next we'll see about mandamus, okay. So what does mandamus means? It means we command, okay, we command. Here we will be the Supreme Court, okay. So here what happens, it is issued by the court, okay, to direct a public authority to perform the legal duties which it had brought to refuse to perform. In case any public authorities have refused to perform any legal duties, then the court will be issuing this writ, that is mandamus. And this writ has been issued if the court finds that a particular office holder is not doing legal duty and thereby he is infringing on the rights of an individual. If an officer is found exploiting the rights of an individual, especially the fundamental rights, then this writ is issued, this mandamus is issued, okay. And this objective of this mandamus is to prevent disorder, okay, emanating from failure of justice that is required to be granted in all case, and there is no specific remedy established in law. See the special work of mandamus, these writs, okay, the speciality, you can say the speciality of this writs is that it prohibits any office holder or anyone to exploit the fundamental rights of an individual, which in case if he or she is weaker, okay. So this court directs a public authority to perform their legal duties, and in case the court found that the public authority is not performing the legal duties, then this mandamus, we command, is been issued, okay. Next we have our third writs, that is quo warranto, means by what warrant, okay, quo warranto. See the name itself we can suggest, isn't it, we can guess by what warrant. So through this writ, what happens, the court calls upon the person holding a public office to show under what authority he holds that offices. See here, in case if there is some suspicions or some in case if a person have another person have appeal to the court that this person is holding a public officer post without cracking any exam or through some illegal means, okay, then in such case this quo warranto is been issued, okay. This writ is been issued like by what warrant, okay, by what warrant you are holding this current position if you are not entitled. Okay, if that person is found not entitled to hold that officer, he may be outcast. That means he will be suspended from there. In case if anyone have joined any duty illegally, then they are being suspended, isn't it? So in such case, this Quo Warranto writ is issued. Okay, and this is objective is to prevent a person from holding an officer he is not entitled to. Okay, if he or she is not entitled to a particular post, then that will be suspended. Okay, to curb such discrepancies, this writ is issued. Okay, it cannot, but see here, it cannot be issued with respect to a private officer, only for a public officer. Okay, government officer. This cannot be issued for a private officer, only for a government officer. This is the limitation of this writ. Next we have certiorari. Okay, certiorari means to certify. It means to certify. It is a curative writs. Okay, here what happens if a court founds, okay, if a Supreme Court especially it founds that the lower court has given some opinion or passed an order which is beyond its power or committed any error of law, then the writ of certiorari may be transferred the case to itself or quash order passed by the lower court or tribunal. So here what happens, if any lower court or any tribunal court have passed any orders which is beyond its jurisdiction or beyond its power and have committed some error while passing that law, then the higher court or the Supreme Court, they have the power to transfer that case to itself and to declare null and void the case which the decision which the lower court have passed. Okay, that means to quash the order passed by the lower court or tribunal. So this is under certiorari. And the next writ that we are going to do is prohibition. See, here you need to understand one thing between this after prohibition. Okay, because in prohibitions also the case has been passed. Okay, but here what happens, the court quashed the order, isn't it, after the order has been passed, but in case of prohibition before the order is passed. Okay, now that is the difference here. Let us see. In case of prohibitions, what happens, a writ of prohibition is issued by a court to prohibit, see the name itself, isn't it, prohibit the lower courts or tribunal and other quasi judicial authorities from doing something beyond their authority. In case if the higher court founds that lower courts are going to pass an order regarding something which is not under their jurisdiction, okay, then the higher court, what can it do, it can pass the case to itself and it can declare, okay, it can declare it can pass the case to itself and it can declare the case as null and void, or any order, okay, not only case, or any order declared as null or void. Okay, it is issued when the lower court or tribunal court without in excess of jurisdiction or in violation of rules of natural justice or in contravention of fundamental rights. In case the higher court founds that this lower courts have issued certain orders, okay, by this lower court in excess of jurisdiction or in case of violations of rules of natural justice or in connection with fundamental rights, then it can pass the case to itself. Okay, so here you need to understand one terms between this certiorari and prohibition, because in certiorari and prohibition both the higher court is passing the taking away the orders which has been passed by the lower court, but here in certiorari the order which has been passed and prohibition the order which has not been passed. Okay, so here in little detail let's see the difference between this writ of certiorari and prohibition is that they are issued at different stage of proceeding of the case. The writ of certiorari is issued after the case is heard and decided, see when the case is decided and passed already, isn't it, and it is to issue the quashed decision to order the lower court, and when the lower court passed an order without an excess, same thing, okay, which we have just done. And whereas the writs of the prohibition is to issue prohibiting the proceeding, okay, it is the case is not been heard or decided, okay, during the proceeding period it will transfer the case into itself, okay, under this writ they have this power. So I hope you have understood these writs as well. Okay, we have completed the writs, and next we will see some significance, okay, like some importance of fundamental rights, which we have already seen here, okay, like we have learned about the fundamental rights. So let us see some of its significance as well. Okay, so what are the importances? Let us see. See, this fundamental are very significant, are very important from the following respect. Let us see in short. There are some 5 points given over here. Okay, fundamental, they form the bedrock of democratic systems. Yes, they form the bedrock because they are the one who is facilitating all-round development of the people, isn't it, and making the people participate in the politico-administrative process. And they also serve as a bulwarks of individuals' liberty and the rule of law by keeping a check on the authoritarianism of the state. So as the people have fundamental right, now the state cannot become authoritarian because they have to ensure, they have to protect the fundamental rights of the person, isn't it, fundamental rights of the people. So in that case it becomes significant, and these fundamental rights lay down the foundation of social justice and ensure the dignity of individual as well. It gives justice, isn't it, justice to the people in case if their rights are violated, and also ensure that their dignity and their dignity of the individual. The individual will not feel that they are been like not treated equally over here. Okay, they protect the interest of minorities. Here there are so many rights that we have seen, isn't it, for women, for minorities, equality of opportunity, no discrimination, isn't it, abolition of untouchability, abolition of titles. So they protect the interests of minorities and weaker section, thus promoting social justice. And they strengthen the secular fabric of the nation because our India is a secular country, isn't it? It doesn't give any importance to any particular religion. So here fundamental rights also ensure secular fabric, isn't it? And the right to religious practice, it gives the person freedom to propagate, profess, concise any religions of his or her choice. So in that way it strengthened the secular fabric of the nation. So these were the significance of the fundamental rights. Okay, now let us move into our next, that is criticism. Okay, criticism of the fundamental rights. I think that will be our last topic for today. Okay, so let us see. So there are certain criticism here. It will include the limitations and all. Okay, there are certain limitations, criticism. Now let us see what are the drawbacks or negative points. Okay, like until now we have studied only the positive one, isn't it? So now let us see what are the negative aspects as well. Here first is excessive limitation. There are so many limitations. Whenever any rights are written, after every fundamental rights, you will see a limitation. There will be a big paragraph of limitation if you go through a proper book, isn't it? There is a big paragraph of limitation, like they should be done in accordance to this and that. So that is why there is an excessive limitations over here. Okay, imposed to the person. That is the first criticism. Next, no social and economic rights. See, there in fundamental rights there is no rights included related to social and economic. See, under economic, right to property was there, but it has been deleted already. Okay, so it lacks comprehensiveness, focusing primarily on political rights. They have only political rights included. There is no social and economic rights, without including essential social and economic rights such as right to social security, employment, rent, leisure, etc. So these are not included over fundamental rights. So there is one negative point here. Next, no clarity, because the words, the language, it is very you can see the constitution of language is also very tough, and the common people, it is very difficult for the common people to understand each and every clause, isn't it? There are so many clauses given under certain rights that we have gone through in a very brief manner, but in case if we have gone through very comprehensively, we will not be able to complete it. Okay, so that is why it lacks a clarity, and a few terms are expressed vaguely and ambiguously without clear definition. For example, public order, minorities, reasonable restrictions. No explanation is given about such words. Okay, like which will come under this, which will come under public order, and reasonable restrictions. Okay, there is no clarity, proper clarity given. And next, no permanency, means fundamental rights can be amended, we have seen, isn't it, but without hampering the basic rights, isn't it? So they are not surrogates or absolute, means there are certain restrictions and they can be curtailed or abolished during national emergency, isn't it? For example, right to property was one of the fundamental rights, but in 1978, after decades of Keshwanand Bharti case, what happened? This fundamental right to property has been deleted from the fundamental right, means there was amendment, isn't it? There was amendment, so that is why no permanency. And suspension during, this is the biggest criticism, you can say, suspension during emergency. Our rights are being suspended during national emergency, isn't it? Except Article 20 and 21, because here you have right to live, isn't it? And it undermines the essence of democracy. It's because in a democracy, who have the power? The people are the one who holds the power, isn't it? So here, seeing that into mind, keeping that into mind, the suspensions of rights during emergency, it is not going upon with our democracy, okay, posing a threat to the rights of millions of innocent individuals, because when you do not have rights, or your rights are suspended during national emergency, you will not have any rights of keeping your opinions, thoughts of expression, everything will be taken out from you, isn't it? Taken from you. So that's why this is the biggest criticism, you can say, okay, suspension during emergency. And excessive remedy. The judiciary bears the burden of safeguarding these rights from legislative, executive enjoyments. However, costly nature of the judicial process impedes ordinary citizens from effectively enforcing their rights through the courts. So there are so many remedies, okay, in order to protect these fundamental rights. So somehow it becomes difficult, okay, it becomes difficult for the court also to look upon each and every things. So there are excessive remedies, okay. Next is preventive detention, okay, preventive detention here. All right, see, under preventive detention, what happens? You can arrest a person, isn't it, without prior information. But what we have learned in fundamental rights, that we have that a person should be informed before his arrest, and within 24 hours he or she should be produced before the magistrate, isn't it? So there is a preventive detention also. That means without, if in case they feel that a certain person is going to cause threat or anything, in order to prevent that threat, that person will be arrested, okay. So that again it violates the rights of an individual, isn't it? So that is why this is included under criticism of fundamental rights. And one more criticism, no consistent philosophy, okay, it lacks a coherent philosophical foundation. According to Sir Ivor Jennings, these rights are not grounded on any consistent philosophy, posing challenges for judiciary in their interpretation. So there is no consistent philosophy regarding this, and it causes challenges before the judiciary in while interpreting these rights. This was the other criticism. Okay, this was the significant, we have already done, okay. Apart from that criticism, these are some of the, like, you can say, good part. Fundamental represents the essence of Indian democracy, serve as a bulwark, isn't it? And it, as India continues its journey towards progress and development, what happens? Prevention and effective implementation of these rights remains imperative, guiding of the nation towards a future rooted democracy, okay. And okay, that's all for this criticism, okay. Okay, thank you. And we have finally completed our big chapter of Indian Constitution, that is fundamental rights, which is under part 3, isn't it? Part 3 of the Constitution. I hope you have liked my session, and that's all for today. But do like the videos, okay, do like my videos and share it with your friends and family, and subscribe to my channel for such daily updates, okay, regarding the Constitution and all. And comment below your thoughts about the questions and today's topic about this fundamental rights, okay. What do you feel about it, okay? And consider hitting the bell icon as well to turn on your notifications. Thank you again for watching. See you again in the next video.